Fair use says it's okay to take somebody else's work under limited circumstances and use it without compensation or without permission.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
When we love something, we usually want to express it to the world. We want to emphasize it. We want to find ways of communicating this love that we have. This is the root of fan-created content. You create art, you create films, you create products, and you want to share them with the world. However, there are some intellectual property considerations that you need to keep in mind if you want to be part of this fan-created content world. And also, if you want to create a business out of it. Let's hear what Professor Marc has to say about it.
My name is Marc Greenberg. I'm a professor of law at Golden Gate University School of Law in San Francisco. I am in the process of becoming a professor emeritus, which means that I will be a retired law professor. In addition, I have been a member of the California State Bar, acting as an attorney in California in the U.S. Since 1979. So I have fairly extensive experience, both as an attorney and as a law professor. I'm a native-born American at the age of 71.
Great. So the way that I learned about you, about your great profile, about your great contributions to the IP world was thanks to your book, Fandom and the Law, A Guide to Fan Fiction, Art, Film, and Cosplay. So first, let's establish what is Fandom or fan fiction, and then we can go from there to start talking about the rights attached to those.
Right. Fandom is a phrase that has been defined in a variety of different ways, but primarily what it refers to in the context of the book that I wrote is those things which are created by fans that are new original works of art or other forms of creation, which are created based on pre-existing material. So if you are a fan of a particular television show, you might write a story for that television show's characters and universe, or you might paint a picture of the characters or scenes in that book or television show. One of the key elements of fandom is to refer to material as fan created. So this is created by fans. A key element of fandom creations is that these are amateur works. These are not, once you start talking about works being done by creators that are in the public eye, that are publicly available, then you're talking about professional work. But the amateur work, which is available for people, is usually available on a nonprofit basis. It's for free. Most of it is on the internet these days. And so that would be kind of what we're talking about with fandom in my book, pertaining to 4 areas of fan creation: fan fiction, which is literary works done by fans about things that they're fans of. So you have, for example, Star Trek romances between Kirk and Spock. That's a kind of fandom that we see. And in addition to fan fiction, there's fan art, which is based on artistic works that fans do based on their favorite elements of fandom. So if they're fans of Wolverine from Marvel Comics, they may do art depicting Wolverine. And so that's fan art. Fan film is a more complex form of fan creation because it involves creating an entire movie. So that involves both a literary work and graphics and design and sound recording and sets and building all of this. Some fans get so excited about the things that they are excited about as fans that they actually go out and make movies based on the same fandom that others are writing stories or doing art on. There's a lot less fan film because of the costs and expenses associated. But as filmmaking has become easier with digital tools, we are starting to see more fan films as well. And then the last area that I included in the fan creation area is cosplay, which is short for costume play. And basically, this is something that you see parodied and made fun of in popular media. Oh, people coming to the conventions, comic conventions like San Diego Comic-Con, wearing outfits, wearing costumes, and that they think of as cosplay. That's really the entry level. Cosplay has become such a serious consideration and activity that there are some people who spend thousands of hours building elaborate costumes and makeup, and they compete in competitions at conventions where they can win prizes of up to $25,000, $30,000 in cash. And more importantly, what they're competing for is an opportunity to have their cosplay viewed by Hollywood producers and Hollywood makeup artists and set designers, and they can get hired. So cosplay is a path towards getting hired professionally as a costumer or makeup artist. And so that's been an interesting and another controversial area of fan creation.
Like an audition in itself.
Yes. At the conventions, and I talk about this a lot in my book, at the conventions for the fan artists, they can meet. So let's say you're a fan of the DC Comics world, and you like Wonder Woman. So
I love her.
So you've been drawing Wonder Woman as a fan and doing fan art. You can go to a comic book convention and sit down with an artist from DC Comics and show your work. And if they like, it's called portfolio review. If they like the work, you might get a job working for the company that you're such a fan of.
So your dream job, you can get your dream job because
absolutely.
If you're good enough and you're in the right place, because you have to meet with the right person, of course.
Right.
You can get your dream job. Wow.
Yes, you can get that opportunity. And so it's interesting because in fan created works, in that universe of fan created works, there tend to be two paths. Some people get into fan created works because they aspire to work professionally in that field, and they see it as an entry path. Other people do it purely for the joy of it. And those are the amateur artists. They don't want to make any money on it. They're excited if somebody reads their work. They're excited to be a part of an art community of writers and others who are interested in the work, that they can exchange ideas and stories. They can go to conventions and meet with fellow fan artists. Those are folks who are not in it for a financial reason at all. Their desire is purely for the community and to be a participant in that community, which is interesting because it means that for Hollywood, you can't get them to behave in ways you might like them to by offering them the prospects of career or money, because they're not interested in that. And so they will vigorously defend their right to create based on your work as something allowed under copyright law and under trademark law, and they're not looking to get financial compensation. They're just looking to be part of a community and for a recognition for their skill.
Okay, so now that you mentioned the law, so let's talk about the intersection of IP in this universe of fan created content. And how you can see it from both sides. So from the side that you would like to have recognition for the work that you do in Fathom, or as the owner of the content that you would like to protect or limit what is created in these forums?
This is a great question. This is a very interesting part of the world of fandom, is this tension that exists between intellectual property law and the desires of fans to create fan-created works based on pre-existing works. Copyright law is probably the law that has the biggest role to play in the fandom world. Trademark also has a role, but it's a lot lower in complexity, I would say. And for the fan creator, copyright's really a two-edged sword, because on the one hand, it protects the rights of the first or original creator who did the work your fan work is based on. Those folks have rights, and so if you violate those rights, if you infringe their copyright, you could get sued and be forced to pay damages or give up your work. On the other hand, the work that you create as a fan, to the extent you have created something new or added something to the pre-existing canon that may exist about that work, that belongs to you. You have copyright in your original work, but to the extent you're building off of someone else's work, you may or may not be infringing, because there's a legal doctrine called fair use. And fair use is the key legal doctrine in fandom. Fair use says it's okay to take somebody else's work under limited circumstances and use it without compensation or without permission. There are circumstances in which you can make that kind of use. Now, one of the best examples of that I use is criticism and comment about artwork. Fair use gives you the right to do that, because fair use says if you take a relatively small portion of someone's work and you use it for criticism or comment, and you're not affecting the market value of that work, and you've taken a reasonable proportion of it, then that is not an infringement of the copyright. That's a huge right. And at the heart of all fandom is work based on someone else's work. So if you didn't have fair use, there'd be no fandom. So fair use is really critical in the law, and it applies both to copyright law and also in a different way to trademark law. There's
How
a
so?
Sorry?
How so in trademark?
Well, it's interesting because first off, you have to step back and say, what is a trademark? A trademark is a brand. It's a brand name. It's how we know and identify something. So, for example, some years ago, before I got wisdom about this, I used to drink Diet Coke like crazy. I used to drink a case of Diet Coke every other day or so. I drank a lot of that stuff. It's pretty awful stuff, but it has a very distinctive taste and flavor. When I look at a bottle, at a can, let's say a soda can of Diet Coke on a shelf, I don't know what's inside that can. I can't see it. It's covered in the can. So when I buy it, I'm buying it with the trust that because I've bought this before and because I know this brand, I know what to expect. If I opened that can and I poured it into a glass and it was orange or green, I'd know it was wrong. Something was wrong because Coca-Cola isn't that color. I have this knowledge of the brand. That's the value of brands and trademark. Now, you use brand names to identify your goods or services, and that's the value of a trademark. So the purpose of that mark is to identify the goods and services. If you, as a fan creator, want to use a reference to Coca-Cola, you're not using it to identify the brand or to sell the product. You're using it for a different purpose, for criticism or comment, or maybe to poke fun. Those are called nominative uses, and it's a term that then gets applied to fair use and combined. And so we say in trademark law, you can make a nominative fair use. And that is a use that is not the kind of use you would make if you were claiming the trademark in the work. And so for that reason, someone seeing your article where you talk about, the decline of Western civilization has been led by Diet Coke, they know you're not talking about the brand. You're not trying to pass yourself off as Coca-Cola Company or as a dealer of Coca-Cola. You're making a fair use comment. And so again, for fans, when fans want to use trademarked brands in their fan creations, if they keep it to the nominative fair use, so it doesn't look like they're trying to impersonate that brand or create confusion about the source of the brand, then under trademark law, you have the defense of nominative fair use. Does that make sense?
Yes, it makes perfect sense. So it's the way that you go about it. So you're not deceiving the public. You're not passing as the brand or the products as if they were legitimate from the brand. It comes to mind when you're talking about this. I don't know if you have seen, there's a lot of fan created product of shoes, especially of sneakers.
Yes.
They buy the sneakers from the brand and then they make something amazing out of it, completely unrelated to the brand, but they keep they keep the identifiers in the shoes. So if it's Nike, Adidas, Jordan, and so forth. So this is a bit of a gray area in this.
Yes, it is,
because you're not claiming that this comes from the brand, but people do identify it as a product from that brand, and it can be deceitful in a way.
It is. That's a difficult case that you identify, because what's happened there is that the additional contribution you've made also adds value. And so it becomes more of a challenge to separate out those values. And the creator who has added something of value and then has enhanced the value of the work. The interesting thing is that in some limited instances in IP law, we've seen this happen where the holder or creator of the original work accepts the new changes and adopts them and incorporates them into their work. And so this is another interesting element in fandom, and we've started to see this in ongoing or continuing series of work. So let's say a television show that's an episodic series, television show, so there are multiple episodes, a book series or comic book series or graphic novel series where we have multiple volumes of the work. When you have that situation and fans develop who are followers of the work, what we've started to see in the last, 30 or 40 years in particular, is a rise of fans communicating directly with the production company and offering suggestions. Suggesting new characters, suggesting new plot directions, suggesting fan created twists to the programming. And the production companies take these on. And some because they've got a rabid fan base, they want to reinforce that base and support it. And so oftentimes I've seen this happen where people make suggestions from the audience at a convention, and it shows up 6 months later on the screen because somebody in the production team heard that suggestion. That's a good idea. We should do that. And so it's fascinating because what this has led to is a blurring of the lines between the amateur fan and the professional.
And also you see that in video games as well.
Yes.
That they have these sandboxes in video games sometimes that people can create anything that they want, and then
Right.
they make new versions of the game and they incorporate this creation, either world building or some character building, or some even the story. So it very much shapes the original content into something else. But it's amazing in a way, but it's also it could be tricky, because if you're do you have the right to use it, even if it's created in your game, it's created in your in your work that you made. Do you have the right to just take it and use it, or do you need to go to that particular fan creator and ask for permission?
It's fascinating as a problem, because what we tend to see is situations where somebody has decided to do a fan created work, and they start building that work, and the level of complexity gets to such a degree that the prospects for infringement are just too high. And it's been very interesting to see how motion picture and television studios have responded to fan works, to fan creations. One of the interesting sort of side approaches that I thought was a very creative one. Paramount Pictures, some years ago, filed a lawsuit against a fan film company that had done a fan film called The Battle of Axanar, which is about the Star Trek world. And what they did is they took from the famous character in the first series of Star Trek, they took Captain Kirk, as it makes a reference in one of the early episodes to how a famous Klingon colonel did well in the Battle of Axanar. And that's it. It's just a throwaway line. If you know the Sherlock Holmes stories, he makes reference in one of the stories to the adventure of the giant rat of Sumatra. And they never actually did a story of the giant rat of Sumatra. It was just a throwaway line. So the Battle of Axanar was a throwaway line in the first Star Trek series. This group of fans decided they would make a fan film of the Battle of Axanar. So they did. And they made like a 40-minute film, and they got sued by Paramount big time for copyright infringement and violation of a million different IP laws. What came out of it was something very interesting. Paramount developed a set of rules, guidelines, they called them, to say, if you'd like to make fan films based on the Star Trek universe, here are the rules. If you do it this way, you won't get sued. You can't use the name of any of the, like you can't say the Federation or use any of the names of our characters. You can't indicate that we're sponsoring or approving this. It can't be longer than 30 minutes. So and it can't be for profit. And then as you're going through this list, then you start to see, and you can't defame any characters, and you can't have characters saying anything inconsistent with the character's typical statements, and they start moderating content. Initially, it's all, you can't use our brand and things like that. That all makes sense. But then they start veering into their controlling content. Now, you can go ahead and do whatever you want. You don't have to follow their rules. But if you follow their rules, you won't get sued. And if you don't, you might. Isn't that an interesting way in which they are trying to shape the way in which fandom and fan creators work with their material? And we're starting to see this, quote, guidelines approach show up with a variety of different creators issuing guidelines on how you can create fan works based on their work.
But it's a very narrow.
Right. That's exactly right. They're putting you into a narrow lane, making absolutely sure it will not damage their brand.
Yeah, but then where is the creativity license, right?
Gone,
Creative license. Yeah.
gone.
Yeah. So
And it makes it even harder to be that creative because you know that you're running a risk because they've told you that if you violate these norms, these guidelines, they're coming after you.
yeah. And then it actually and it harms the fun because the fun is you can see it from their perspective. Like I'm just trying to honor the work. I'm trying to further get myself inside this beautiful universe that I enjoy. So I just want to dream about it and create about it. So it's, yeah, from the fan perspective, it's like, oh, you're mutilating my art.
I saw this as a very negative development in fandom. This business of coming up with guidelines, because it contributes to the atmosphere of fear,
Yeah, exactly. Exactly.
and fear kills creativity.
Yeah. And the moment you tell them everything that they cannot do, is like, yeah, but what you're telling me that I'm allowed to do, I don't want to do it.
Right, right, right. It's an
Yeah,
artificial constraint. Yes.
exactly. So, apart from these guidelines, what other legal considerations should fund content creators should keep in mind regarding IP and regarding specifically trademarks?
Well, one of the areas that has been very controversial in the world of fandom has to do with this topic we've mentioned before, this concept of fair use. And the definition of fair use has been a constantly changing landscape. And so this is something that I encourage fan creators to pay attention to, is to find out what the latest cases are in the area of fair use, so you can have a sense of what you can or cannot do. There is a concept in fair use law that is called the transformative doctrine. And what this means is that if you have, and let's say you take an original copyrighted work, let's say it's your story, it's the story of the first Star Wars movie. That's the work you're taking. Okay. Now, copyright law says that if you create a derivative work, a work based on the original work, you've now created a derivative work. So let's say you've taken a book and you made it into a movie. That's a derivative work. It's a work derived from the original work, but different. Okay? That's a derivative work, and the creator of the copyrighted work, the person who created the original work, they also own the right to create derivative works based on their original. Sometimes they do that by, let's say, if I wrote Star Wars, the first episode, then I create this volume 2 as a derivative work based on volume 1's universe. Okay? So that's how you can do that. What this transformative doctrine says is if you create your work based on someone else's original work and you add new elements, we will say that you have transformed the work. And if you've transformed the work by adding new elements, we will say that that is not a copyright infringement. You can have a copyright in your newly created work and you won't get sued for the previous work you took from, because you've transformed it. That's the transformative test. Now, it's a 4-part test. Requires 4 different elements that have to be analyzed. Courts have been all over the map trying to figure out what is or is not a transformative work. Some courts have looked at some things and said, yes, this is clearly transformative. Others have said, no, it's not. And so there was a series of different cases that came down, and I discuss all of these in detail in my book. Series of cases that came down about the limits and the scope of fair use. Now, obviously, this is very important for fan creations because all of their creations are derivative works. They all start with somebody else's work and then they build off of that. That's the essence of a fan created work because it's a fan. You're admiring of somebody else's work and you wish to use it in your own new work. If the transformative doctrine protects you, you have a very broad range of things you can do. If it doesn't protect you, you're going to be infringing people's work and you're going to get sued for copyright infringement. So the scope of the fair use law is really critical to understand in order to effectively be a fan-based creator. But the law's shifting and changing like the sands in the desert. And the Supreme Court has recently, in a case, Goldsmith versus the Andy Warhol estate, walked back the broad grant of fair use rights they've given in the past, and they've pulled it back and said, no, we think some things can be infringing. That particular case, the Goldsmith case, Lynn Goldsmith is a photographer of rock and roll artists. She took a famous photo of Prince when he was a young artist, and it ran in magazines, and she sold copies. And Condé Nast came to Andy Warhol and said, we want you to create an original artwork for Prince to commemorate, I think it was like the 10-year anniversary after Prince had died. And so Warhol took Goldsmith's photo of Prince and did his typical treatment, multicolors and sort of shadowing and so on. And they ran that in the magazine. But then what Goldsmith didn't know about, because Goldsmith was aware of this, she was okay with that. What she didn't know is that Warhol did 10 other iterations of the Prince graphic. And then after Warhol died, the estate of Andy Warhol was selling them for thousands and thousands of dollars. Goldsmith sued. Warhol's estate said, transformative fair use. Pretty straightforward. I mean, clearly Warhol's treatment was not the same as the photograph, and what came out on the other end had new expression that he'd added. This time, the Supreme Court, the District Court and the Court of Appeals both said Warhol estate's right. This is a transformative fair use, no infringement. U.S. Supreme Court reversed. They said, we think this goes too far. We think that you haven't added anything really new or original. The base of the work is still the original photographer's work, Lynn Goldsmith's work, and you're using that without permission or giving her any compensation. This is not a fair use. Well, that threw the whole legal arena into a dizzying spin, because we now don't really know just how far you go to have a transformative fair use or not. It's very much up in the air, and we are, as Indiana Jones said years ago, making it up as we go along. We're still trying to figure out what the parameters of the law should be. So for fan creators, I encourage you to be careful with transformation doctrine, and don't just think it's okay. You should definitely have counsel review something if you think that potentially it could run into a copyright infringement problem, or if you're trying to rely on the transformative defense, you need somebody to analyze it based on the latest cases.
It has become a case-by-case kind of, which is something that is extremely nerve-wracking when you are trying to know which side of the law are you going to be standing, especially if you don't want you get yourself in trouble. You're trying to avoid legal issues, but if there's no clear path, then you don't know. Well, it depends on if I get sued or not.
Well, it's a term I used years ago in a law review article I wrote. It talked about the chilling uncertainty.
I like that.
And I think that's what happens here, is that you're your expressive desires, your interest in creating is chilled by the fear that you could get sued for what you create.
Yeah. And even if you're trying to be careful, you don't know how careful you should be. Yeah.
And that's really important. It's very important to understand that because risk taking is part of being an artist, but you want to be informed.
Of course.
You want informed risk taking. And the kind of risk that comes out of nowhere where you had no idea that this could potentially be a problem is very destabilizing.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property.
Now, we cannot talk about fandom without social media because it is the universe in which we all exist now. And this is where everything happens and communities get created and work gets published, emphasized, shared, and so on. So how does social media amplifies the legal challenges and make it even harder or better, according to how you see it, for the creators and also for the brands?
Great question. And social media and the internet in general has both become hugely valuable in fandom. If you want to write fan fiction now, there are thousands of sites and millions of pieces of fan fiction that are distributed on a regular basis. So there's a tremendous availability and opportunity for people to work on various platforms. There's a platform called Archive of Our Own, which is a fan fiction platform. They have thousands and thousands of young fan fiction writers on that platform. It's a safe platform. Archive of Our Own. There's another one called Deviant Art, which is a fan site for artists. A lot of fan art goes up on Deviant Art. There are always a couple of things that I encourage fan-based creators to pay attention to. One is the TCU, the Terms and Conditions of Use, the TCU, which governs all of these different websites. So, for example, a popular site to put up fan art is YouTube. Very popular. The terms and conditions of use for YouTube say anything that you put up on YouTube belongs to YouTube. They can take it, they can use it, they can modify it, they can alter it, they can do whatever they want with it. You give up a certain level of your rights by virtue of these terms and conditions of use. So what I encourage anybody who is a creator who wants to upload material to social media, get into their site, find out what the terms and conditions of use are, or whatever else they want to call it, guidelines, regulations, submission guidelines, know what they can or cannot, what the site can or cannot do with your content. And this is a vital thing for people who are creating content to make sure that they know what can and can't be done with their content. And oftentimes they don't realize that there are some significant advantages that they're giving away.
A long time ago, I wrote an article about social media, and I read most of the terms of back then, and it was terrible.
Yes.
Everything that, and I remember that LinkedIn, I don't know if they changed it because it was many years ago, LinkedIn had ideas, also has something that you were giving away by being a user. Ideas, like something that is not exactly, it's like they own your mind. It's like something that is not even protected, cannot be protected through IP, so they own it. Like
they're doing it by contract.
Exactly. So whatever thought you have using their platform, so according to their terms, is theirs. Yeah. So it's very important to be informed, especially if you're using it has the the channel of making yourself known, making your art known, making your content known is very, very important to understand where you're giving up and where you're accepting, because it's a great tool for you to get a platform. It's a great tool for you to publish your work, but also you can be taken advantage of, or you can
Yes.
be giving away more than you would like.
We talked before we started today about the question of legal literacy and the ability of people to understand what the law provides and what their rights are. And for far too many creators, there is little opportunity made available to them to understand the legal obligations and benefits that the law provides for them as creators. And far too often, if you think about your daily life in this contemporary digital world, on how many days is somebody trying to scam you, trying to get in and get your money, get your assets, get control of something that you own or have? It is a predatory universe in the online world. And far too often, I find artists are too innocent about that. And they don't understand, they can't believe how venal and awful some folks can be in trying to get their creations away from them, in trying to take their work and not give them attribution or any compensation. And so what I tell young artists all the time is, if you want to make art for your family and your friends, and you don't want it to go beyond that, you don't need my services. But if you want to get involved in the selling of your art, now you're in business. And if you're in business, you need to know the rules.
Of course.
You need to know how this business is done. Because if you don't, you'll get taken advantage of. I used to teach a class called Legal Aspects of the Music Business. And I taught this course to musicians who had never had any interaction with the legal business, but they wanted to get out into the music biz. And I told them, all of you right now, you are guppies. A guppy is a little tiny fish. I said, all of you right now are guppies in the sea. By the time we finish this course, you will be minnows. Minnows are about this big. And I said, and the sea is full of sharks. So when you're a guppy, you don't know enough, you just get eaten. When you're a minnow, you know enough to maybe swim out of the way. That's about the best I can do for you. I can't change the leverage. You won't have the leverage. You're a young artist starting, they're a big production company, but at least you should know what they can do and how they do it. And you should know how to try to protect yourself. And frankly, the law provides for some protection. Copyright law and trademark law do provide protection for creators if they know how the law works and they use it.
I love that analogy. I love that. It's very much like I give you the tools just enough for you to defend for yourself, and then find more tools that keep growing, keep going up in the
That's
chain.
That's it. The artists that I work with, actually all of the artists that I work with these days have at least 30 or 40 years of experience.
Oh, wow.
They are deeply experienced. They're all, in their 60s, 70s. They're still creating. These artists know. They have been through all of the terrible times and the predatory efforts. And so they've got a tough skin. And they work with me, and together we protect their rights. But it's a constant battle, and it is war. It is aggressive battle. Yeah. I have to stand on the podium and stomp my feet and raise my voice and do everything I can to use every power I can to get my clients for their rights.
Oh, so it's very much about making uh, making your right known, understanding your right, and making it happen.
Yes.
That's one of the things that a lot of creators, entrepreneurs, creative entrepreneurs also don't understand. That the thing about IP in general, and in part, and very much is a very much of a right that you need to assert.
Yes.
It's not gonna come out of thin air that, oh, okay, so this is my right and they're gonna recognize it. No, you need to really assert your right and make sure that is being respected, because you have to be vigilant. You have to pursue anyone who's doing unauthorized use, pursuing anyone who's doing anything that is infringing your rights. Because if not, it's not going to happen. No one is going to pursue it for you. We do have some, of course, some sort of cases that it is enforceable by the public means, and it has to be pursued publicly. But it's not the great majority, and
No.
it's not necessarily gonna. Even that is not necessarily gonna happen without you being behind, without
Well,
you.
you earlier talked about talking to the client who gave in. This happens a lot because artists have a lot of, and creatives have a lot of fear. Oh, I couldn't sue them. How could I sue somebody? Oh, they have all the money, they have all the power. Oh, this is just how things always are. Yeah, the little guy always gets screwed. That's just life. It requires, to protect your rights, a willingness not to give in like that. There are lots of sad cases like the one that you talked about, where lawyers get involved and they're actively working to defend their client's rights, and the client gets nervous and caves in, accepts a poor deal, withdraws their claim. And so much of what I do as the lawyer, remember I was talking about the counseling function. A lot of that, I had this experience just recently. I had a client who had been in a terrible relationship with a very manipulative fellow who was serving as his manager / lawyer, and we had to deal with litigation. We had to file a lawsuit to get rid of this guy, to disentangle him from royalties. He had his fingers in a lot of my clients' money. And when we filed a lawsuit, my client had never been involved in a lawsuit before. And I explained to him, listen, you need to understand that in a lawsuit, it's like being on a river cruise. Some days you're up, some days you're down. And there will be ups and downs throughout the process. It was really helpful for me to give him that context, because when we hit a bad patch, he understood. I had told him, oh, well, this is one of those bad patch times, huh? When you're going down. I said, yeah, we'll be up we'll be doing well in a week or two. And sure enough, we were. Clients need to understand that there is that rhythm that goes on back and forth, because standing up takes a lot of courage and takes money.
Of course.
I mean, it's a sad reality that there are very limited resources, legal resources available to creatives if they lack the ability to pay legal fees.
Yeah, that's the case that I was telling you about before. It was a very particular. It was a very straightforward case. It was such a clear violation. A book publisher took visual content without the authorization of the visual artist. There was no question about that it was his work. There was no question about the infringement. It was extremely clear. And he talked to me let's say, today, and the next week, he called me again to say that he already signed and gave away his right because he didn't
Yeah,
want to fight them because he thought he didn't have, he thought himself as not worthy of a fight.
right, right.
And there was nothing I could do. I mean, it was
There isn't.
and with that case, he could have been set for life because even though he was himself a very popular, established visual artist, he wasn't nearly as had he should have been economically because probably of this kind of mentality
Yes,
because he saw he saw himself as not worthy,
right.
and there was nothing that I could do as a lawyer to change his mind.
No, there isn't.
So, and it was and that happened many years ago, over 10 years ago, and I feel it still today. I feel the pain still today. Because
Well,
for me it was like, oh my God, I was like, we were we could have changed your life with this, and just by starting the lawsuit, and settling, because I didn't want to go all the way to the Supreme Court. No,
sure.
just a good settlement for you could have changed your life. But he had other idea.
Yeah, well, that fear is very powerful. And it's one of the reasons why, after practicing for 21 years full time, I became a part time lawyer and a full time law professor because I realized that there was a crying need for education, not just about education of artists and creatives, but education of lawyers to represent artists and creatives. One of my friends in the comics business writes a Substack with her observations on a long career in comics business, and she recently wrote a piece about legalese, and more importantly, the need, if you're a comic artist, to find an attorney who knows your industry, because this is one of the other things that creatives run into and don't understand. You're particularly fan creators. Let's say they get they do a piece of fan fiction and they get a note from a publishing company saying that this is infringing, and they take it to their cousin who practices real estate law, and they say, "Cousin, can you help me with this?" And cousin, who's bored with real estate law, here they're looking at a cool publishing law case, very interesting. Oh yeah, sure. And then they just mess it up badly because they don't know the industry standards, they don't know the leading cases, they don't understand how leverage and negotiating power works. There's a million different things that you don't understand, and one of the real dangers in the creative arts arena is wannabe lawyers who want to be creative rights attorneys, and they don't have the knowledge or expertise and think they can, read a law review article or two and do it. And you can't.
Oh
And
my
so
God.
creatives have the
Yeah.
difficult task of having to stand up for themselves. And as I explained to them, you will, if you have a hairdresser who you don't like, you'll drop them in a minute. Why wouldn't you do that with your lawyer? We're service providers like the hairdresser. And so shop for your lawyer. Make sure there's somebody who can do this kind of work and has experience doing this work. There are experienced lawyers out there. Now, it can be difficult. I received a phone call one day from two young men up in one of the more rural Midwest states, wanting, they'd heard about me through one of my books, and they were interested in hiring me to represent them. They wanted to launch a comic book company. And I said I was happy to do that. And I quoted them what my hourly rate was. There was an intake of air as they, oh my goodness, that's very expensive. And I said, it is expensive. The fellow said, well, lawyers around here in our rural state, they work for a lot less money. And I said, you're absolutely right, they do. But the problem for you is to find the expertise that I have. You have to go to Los Angeles, San Francisco, New York, Chicago, the major cities of the United States. And the cost of legal fees in those cities is what I'm quoting you. And so it's an unfortunate reality that specialized expertise in law, which is what you need to work on in this arena, is going to be expensive.
Of course. And you get what you pay.
Yes.
If
And
you got
also, I sometimes I'll get a client and I'll explain, well, you can register your work for copyright. It's there's a $40 fee. Oh, geez, I don't have $40. You know what? Get out of the business. If you can't afford anything, you got to make a little bit of money and spend a little bit of money to be able to make some success, and you got to be able to protect yourself.
Of
and
course,
unfortunately, in the U.S., the way that works is you've got to be able to pay for lawyers.
And it's not a cost, it's an investment.
Well, it's an investment. It's also, thankfully, under U.S. tax law, fully deductible.
Perfect.
on your taxes. This is a business expense. So if you're a creator and you're creating works, you're spending money. This is a business expense. So if you sell your work and get money in exchange, you deduct the cost of this business expense from your taxes. So there's no reason not to get legal counsel.
Oh, yeah, but that's amazing. That I didn't know that. That's a great point and something to keep in mind.
Absolutely.
So now let's talk about the developments or the legal developments regarding this fan created content and where do you see or where is the law heading towards?
Well, probably the biggest new development that's going to have a big impact on fan created works is AI. Generative AI programs can create fan fiction, fan art. All you do is put in a prompt and the work gets created. So it's going to be very interesting to see how that has an impact on the fan community, because so much of the fan community is based on the fans' effort to kind of replicate the works that they love, and they put their passion and their love for the particular show or television character or book character into their fan created work. It seems to be a different order of effort if I can create fan fiction by saying, give me a Star Trek story in which Spock and Kirk have a love affair. And generative AI spits it out in 5 minutes. The whole process, the love of it, the creative process really is changed by this. There's also the problem in AI of what's called hallucinations, which is we're seeing this with AI doing text. Let's say a friend of mine actually did this. He put in his resume and said, generate a resume for me. And it came up with jobs he'd never had.
Oh, no.
Right. Case briefs that have been done using generative AI, all of a sudden there's a citation of 10 cases. They're all made up. They don't exist. That's what's called hallucinations. So if you're using a generative AI program to create fan-created works, you have to be cautious about hallucinations. You got to go back through and read everything to make sure that it didn't go off in some weird tangent that the algorithm just thought made sense and it just threw it in. We're seeing a real interesting pushback in fan art about generative art created by AI. So one of the interesting legal issues and battles we're dealing with is whether or not you have to watermark your artwork. So you put a marking on it to say there's no AI in this, or created using AI. So that's one of the big issues is disclosure in AI. Should you, as a creator, have to disclose that portions of your creative work were created using a generative AI program? And we saw another big issue that we're seeing with this is the ability to create deepfakes. So I can take a generative program to say, give me an image of Jennifer Aniston, the actress, and have her smoking a cigar. She may not have ever smoked a cigar in her life. I don't think she has from the look of her. And she may not want that association. So you have to be careful in creating generative AI works, not to violate people's rights of privacy, not to violate their right of publicity, their celebrityhood rights. And AI allows you to do a lot of that. So I think probably the two trends that I think are the most important to watch: what happens with fair use after the Goldsmith-Warhol case? Are there going to be more iterations on that question? And what is the impact going to be of AI on the fandom world and the fan-based communities? And I think those are the two areas that I'd be looking at.
And I read a few days ago that the AI that learns from AI created content become less effective. So the more the AI learns from AI content, the less quality of the content becomes. So this debunks a bit the idea that creators are going to be completely replaced by AI. At least at the stage that they are right now, they still need human creators to draw from and to generate from, because the way that we create, the way that humans create, is still cannot be completely replicated by an AI.
I agree with you. I think, though, that what we're more likely to see as a result of the growth of generative AI programming is a two-tiered system of creative works. For those who are wealthy and can afford it, they can get original, new creative work by live human artists. For those with less resources, they'll get generative AI.
Yeah.
They'll get works that were created using generative AI and very little in the way of a human hand. In the same way that there are inexpensive stores, discount stores, where you can buy cheap reproductions of art. So this is the art that you buy because you want that. There's some red in this, and you have a red couch. That's the criteria for that kind of art. For the cheap knockoff dime novel, that sort of thing, a lot of that's going to be created by AI because it's going to be cheaper to make.
And also the combination of both of them, because you can use AI for editing, you can use AI for a lot of things, so for just brainstorming as well, like tell me 100 plots of these two scenarios, things like that. So it's not that it's not to use AI, it's how to use it into your advantage.
It's a tool.
And exactly, it's a tool. And you can enrich your originality through this tool. But as it is right now, it cannot really replace human creativity for now. Until we create a super intelligence, then there's another story.
That's another story. No, I talked with an artist client of mine, and I said, what do you think of AI? And she said, I love it. I said, what do you mean? And she says, oh, it's great for making brick walls. It's great for making a dirt field. It's great for clouds, great for trees and leaves. Simple things that are repetitive, that would take her hours to draw. She can use an AI generative program and bang, there it is. But will she ever use an AI program to draw a face? No.
Okay.
To draw action? No. To show grief? No. It doesn't have that nuanced level. The other point you were making about sort of the quality, the interesting thing, which I read about AI recently, and I thought was a good comment. The whole concept of generative AI starts with data mining. So you have a giant data set that you have to upload, and then that becomes the basis from which the algorithm can create new works. which means that everything that it creates is based on something that's already existed. So where is that flash of brilliance from a creator who does something that you've never seen before? I happen to be a big fan of visual arts and graphic arts in particular. I'll come across a new graphic artist who has a technique I've never seen. I've never seen that look. That sparks my interest. That engages me because they've added something new to the creative universe. Can't really do that with AI. It's all based on things that have previously existed.
I love that. Yeah, it's true. It's true. And with that, how do you foresee the future between fans, creators, production companies, and what do you foresee as the relationship moving forward, especially with these guidelines, these new ways of let's see, like limiting the creations, the fan creations?
Well, I think fandom is going to continue and flourish. It's a wonderful thing that we have opened the tap on all of this creativity and all of this pent-up desire to create things, to make things, to love the works that you enjoy, and to want an homage to those works. So I don't think fandom goes away with the challenges of AI or fair use legal doctrine. As long as the one thing that kills the intellectual property arena is effort to suppress the creative desire and creative urge. As long as we can avoid that in our analysis and use of law, and use law to support the creative process rather than suppress it, society benefits, the culture and the world benefit. To the extent that the law becomes a weapon of suppression, of expression, whether it be in the arts, in politics, wherever, suppression always leads to bad results. And so I have to say that I'm cautiously optimistic for the future, but I recognize that things could go in a way that we hope they don't.
So let's hope for the best and prepare for the worst.
That's how you got to work.
Thank you so much for this amazing talk. It's been a great pleasure meeting you and learning so much from you. I feel like I would have loved to be one of your students because you have a very engaging way of talking about law related issues, and this is something as a lawyer and in another lifetime a law student is very much appreciated, because when you make it so interesting to listen, to understand, and so easy to understand, it really must feel like you can tackle any legal issue without any problem. So thank you so much for sharing.
Thank you. I strongly believe that legal education is about a tool set. If I give you that set of tools, effectively give you a set of tools, you can then use it for anything. And the law is as diverse as human experience. And so I think it's great fun for me, and I take great pleasure in seeing my students go forward and engage in the creative communities, help creators, help the arts. Nothing gives me more joy and pride.
Thank you. Thank you.
Thank you.
And yes, if you would like to give your socials, where some potential clients may find you, please go ahead.
Well, I'm reachable at MHG, in my initials, Marc Henry Greenberg, MHG, at Marc, M-A-R-C, Greenberg, Greenberg, law.com. So MHG at marcgreenberglaw.com, and I'll be happy to get back to people. I will tell you, as I explained to you, I have rock star hours. So I never do anything early in the morning, and I am on the Pacific Coast here, so it's Pacific Standard Time. And if you get a note from me at 3 a.m, it is me, and I am up then. So I look forward to hearing from anyone who's interested in having further discussion on these topics.
Perfect. Thank you so much. Thank you for your time.
My pleasure.
And we will surely invite you again soon.
Thank you. I'd be happy to come back.
We have reached the end of our episode. Greetings from Switzerland.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.